Good evening, everyone, and welcome to our Rights at Night with the Georgia Association of Educators. Tonight, we have an exciting topic, and our Legal Services Director, Mike McGonigal, is going to explore for us social media and how social media impacts educators.
Okay. Thank you, Sharon. Got to find share screen. Do that. Slideshow.
I hope everyone is having an exciting time as we're starting school. I am Sharon Doe. I'm a high school physics teacher in Augusta, Georgia. And I was really excited this year because I get to teach a new subject, scientific research. And so that's always been interesting to me. I hope all of you are having wonderful starts to your school year.
Okay. Anybody else want to offer any reflections before we dive in? I know we're hearing issues about planning time, but we'll save that for another day. So as Dr. Doe mentioned, I'm Mike McGonigal. I'm the Legal Services Director, General Counsel at GAE. And President Morgan asked me to put together some slides on tonight's topic, which is technology, social media, and you. I always have to plug our legal services program because it really is a better program than any competitor that we have. We have more of the liability protection than others do, but liability protection covers you if a lawsuit is filed against you, say by a parent on behalf of a student. Every program year, we see maybe 5 or 6 such lawsuits. And while nobody wants to be sued, that's a pretty rare occurrence where our program is superior and better than others is the employment defense and certification defense, where we have no predetermined cap on the amount that we expend in defense of your job or your license. Other organizations cap a case at $10,000, but you never know when you're going to run out of that money, and you have a great case that needs to go on up to the Court of Appeals. So we're provide more value for the dues money on that. We also, what makes us different is that we file affirmative lawsuits on behalf of members. And when we do those, I mean, I begin thinking of a budget of 25,000, 50,000, and certainly a lot more. Some cases to get to the summary judgment will take us into $100,000. But we are very committed. We are backed by the NEA, as you know. And so we have access to tremendous resources through NEA. And I'll plug the Divisive Concepts lawsuit that we are planning to file in the near future. And if you don't know what the Divisive Concepts law is, if you know the name Katie Rinderly, a 5th grade teacher in Cobb County who just got fired for reading a book that the board felt was divisive, that's the law that we're going after. No other professional organization has the resources to pull this thing off. So stay tuned for our lawsuit on the divisive concepts statute. I always find a lot of wealth in Georgia and GAE's history. It always unlocks a lot of doors for me to see where we were and how relevant our history is today. And there's a couple books on the bottom of the slide. If you want to take a picture and buy them, they're very well worth reading. They're about Horace Tate was our first African-American executive director. The book is about his upbringing in Jim Crow South. And Ulysses Bias, the second book there, he was also a GA member, and the book talks about his fight through Jim Crow South and how he, when they were trying to integrate Gainesville City schools, they actually gave him a meaningless promotion to the central office because the community there, the white community, was quote unquote not ready to have a Black man in charge of a school, in charge of white educators and white students. So it's a fascinating book. I also just want to spend just a minute, it's just about a 2-minute reflection on GAE's strong connection to Juneteenth, because I find a lot of wealth in knowing about our history and what it means for us today. Did you know there's a strong link between Juneteenth and GAE? There definitely is. GAE's Black founders were formerly enslaved people. After the Civil War, Black Americans came together and formed the Georgia Teachers and Educators Association, or the GT&AE, in 1878. Before freedom, enslaved people could be beaten, whipped, or killed for daring how to learn to read and write. That's the power of racism and the majesty of education. Then something incredible happened. After Black Americans fought their way to liberation, they continued to risk their lives by forming their own professional education association after the first Reconstruction ended. They built schools and taught Black school children how to read and write, something they knew would expand their freedom. As Frederick Douglass wrote in 1845, once you learn to read, you will be forever free. Context and scope are everything. Where we start a story is political. What's included and what is forgotten, what is centered and what is marginalized matters a great deal. One cannot talk about GA without talking about the emancipation of the enslaved and our GT and EA founders. GAE's link to Juneteenth is especially relevant in 2023 as our efforts to expand our multicultural democracy are being met with frantic efforts in Georgia to censor educators, ban books, and impose desperate measures to suppress the teaching of slavery and racism. GAE Legal Services is doing its part in the fight for equality, demonstrating this department's commitment to diversity, inclusion, and educational equity. So with that, we'll go to, I really want to encourage folks, again, to chime in. I had scheduled a media specialist to join us tonight and share her experiences in the media center. So I'm a bit of in the ivory tower, but folks, tonight you are in the classroom, and feel free to chime in at any time and try to have some conversations going. This slide is just something that came along from the Pew Research organization, just to show, technology is a blessing and a curse. 95% of all students have a smartphone. 45% of all students say they're online almost constantly, probably in your rooms. 96% have a home computer, and 75% of low-income students have a home computer and game console. So technology is certainly here. It's prevalent. It's everywhere. It's a part of the fabric of our society. What the Pew Research people are saying, the majority of teens get their information from YouTube, TikTok, Instagram, and Snapchat. Those are the main purveyors and communication for teens: YouTube, TikTok, Instagram, Snapchat. And then following behind is Facebook, Twitter, which is now called X, Twitch, WhatsApp, and Reddit. So the Pew Research, again, it's a very good organization, has tons of statistics that can, I think, answer a lot of questions that we have. The golden rules, I think, just to impress, it may seem self-explanatory, but nothing's private. Nothing is private. Nothing is private. And nothing is permanently deleted. And that includes Snapchat snaps. They're called snaps. They disappear, the little pictures disappear from your phone and the receiver's phone, but not quite. The Pew people point out that those snaps, they may disappear on your screen, but they become embedded in your phone. And those snaps are recoverable in the cache memory of your phone and the person that you sent it to. So people think Snapchat, it's deleted, and yay, I can send something and not get caught. That's not true. And the Snapchat company keeps it on their servers for 30 days. So they are not as delete proof or delete friendly as you might think. And for everything else, trust me, when we do litigation, we immediately go to laptops and cell phones of all the decision makers and board members and superintendents and all the rest. And we get our hands on some very incriminating information through forensic computer experts. Very helpful. Just a rundown of some of the state laws that govern the internet and social media. Computer-related crime, Title 16 is your criminal code. That particular statute governs theft by a computer and invasion of privacy. Identity fraud is covered in the next statute, 16.9.122. Terroristic threats, something that's been around, forever. Making threats against the bodily, the person, and the bodily, threatening bodily harm to an individual, specifically has been around forever, but now you can be found liable for that under the Georgia Criminal Code. Anything that encourages terroristic acts or promotes civil unrest. And I have not read the Fulton County indictment of the Trump crime syndicate, but I think some of these threats on computers and social media and the handhelds may be coming into play in that particular indictment. And former President Trump has also been warned on his bond not to threaten people or intimidate witnesses. And this particular statute may just be the one that the court is leaning on. Furnishing obscene materials to minors, anything that's sexually explicit, obviously illegal. Child exploitation and prevention, that's child trafficking, obviously. And the last statute that's is of importance for us, 20-2-324. The 20 is the education code. It mandates that every school system in the state have an acceptable use policy, an AUP. And so, the question for the group tonight, have you read your school district's acceptable use policy? When was it updated? I've looked at half a dozen already, and they're all they were kind of like put into place when this law came into effect, and then everybody forgot about it and didn't update it. And most of the policies deal with computers. They don't even deal with social media. So you need to go and look at your school district's website and read the acceptable use policy if it hasn't been updated. That's something that your local association could take on and work with updating the AUP, and as well as either creating or updating a social media policy as well. So just a couple of federal laws that come into play. Children's Online Privacy Act, that actually prohibits the collection and use and disclosure of personal information of children on the internet. That's actually very related to FERPA, as most of you know what FERPA is below. And the Internet Safety Act, I learned that since the school district receives money, the federal government has standards and requirements for having proper internet filters on the school's internet. And, so that's in place. And that's something else you can ask your technology expert at school. What are those filters? When have they been updated? And of course, most people are familiar with FERPA. And that, again, is a Students' Privacy Act, and an online communication that's can come into play as well. So I thought it's good to reflect. I think to keep educators out of trouble, these are just some of the reflections that I think may seem common sense, but when people call me, they're usually in trouble, and they don't take time to reflect on the who, what, where, when, and why. So, you have to ask yourself, what's my role as an educator at school and in the community? And whether we like it or not, we are representatives of the community. And sometimes our online activity may not reflect well on the school, but of course we have First Amendment rights, and I'll get into the First Amendment later on. But it's important to know or keep in mind, what's my role at school and in the community, and then what am I saying to this other person? Before you hit send, is that something that you want to see, splashed on the television or the front page of the newspaper? And so where is this taking place? So if it's a verbal communication, that's not archived. This is really where it gets to nothing. If you're using technology you can assume it's going to be there forever. And lawyers are going to hire forensic experts to get at it. And the school district will too. I've seen cases through GAE where laptops are confiscated. The school district technology director runs their program on the computer and finds sexually explicit images on the educator's laptop, and it doesn't take a lot of expertise to do that. But just, nothing's deleted, nothing is private. And then you have to reflect on, well, when is this conversation occurring? Is it, am I communicating online, at midnight, and you could have legitimate educational reasons for working that late. I hope you don't work that late, but what I'm trying to say here is the context is everything. That conversations after school hours, late at night, or in the wee hours will raise some eyebrows if the substance of the communication is somewhat questionable. And then last, why? So why am I having this conversation, with either friends or with students? What's my motive? What's my motive? And people that investigate, I don't know, I guess I call them e-crimes or inappropriate use of social media and technology. When it gets into the sexual area, they're going to be looking at grooming behaviors. Is the conversation taking place late at night? Are they really grooming this particular individual to have a sexual liaison? So, what's my motive? Who, what, where, when, and why? Good ideas to keep in mind when we're using technology and social media. So I thought I would approach, because code of ethics is something that I have studied for over 20 years, and it gets into cases, it gets into the do's and the don'ts. So these are the standards that we see implicated in social media type cases. Standard 2, obviously, conduct with students. That's the professional boundary rules. You're always the adult in the room, always the adult. Standard 4, honesty, can become implicated if you're not being truthful in an investigation. We've seen instances of that where the educator is not being truthful. And that alone in and of itself can be another charge, even if the underlying incident is perhaps not as bad as one might think. If you're lying to an investigator, they will tend to come down hard on that individual. Standard 5 is implicated. Obviously, the school's computer is for school business. It is not there for personal business. We'll get into some little Q&A later on, but don't balance your checkbook, personal checkbook, on the school computer. If you're working on an advanced degree, that's education related, I get it, but if you're going to use the school computer after school because it's convenient, make sure you get permission, because really that is your personal business, working on an advanced degree. Standard 7, confidential information, often implicated in social media cases. Are you disclosing, grades? Or are you disclosing a student's behavior or conduct at school? That sort of thing on your Facebook, or on any other application, say TikTok, for example. And then the standard, or I mean the kitchen sink standard 9 professional conduct, it says that, you know, it's very broadly phrased, and it's in my years working with members and defending members, standard 9 is like always present. They always will plead standard 9 because of their thought process as well. If GAE prevails under standard 2, conduct with students, we might be able to persuade the judge that they violated very broad standard under standard 9. So besides the standards, you also have reporting requirements that can be implicated in any ethical situation. And then, of course, there's always mandated child abuse reporting that can be implicated in technology and social media cases. So I'm going to stop right there and just ask if there's any questions or clarifications that are needed. I see a hand. Sabrina.
I had a question about the Wi-Fi in the school. You were talking about not using the school computer to do, you know, if you were working on an advanced degree. You know, what about if you had your own computer and you were working in the afternoon with maybe somebody else from the school, and you were using the school Wi-Fi? How does that play in?
I think you can use your own personal computer, but the way I understand it, you're still going through their system. And I suppose I've never seen this, Sabrina. I suppose somebody can argue you're using the school's Wi-Fi, which is a public taxpayer financed technology for your own personal use. But I think that would be so nitpicky and petty as to just really say, you know, that let's be serious about it. That's my take on it. Miss Nunn Jones, asked to unmute. Oh. Can you unmute?
Sorry, I was thinking along those same lines. Like if you're working with coworkers after school and you have your own laptop, are they able to tell if you're using their Wi-Fi?
Yes. Yeah. Yeah, from a technology perspective, they can. Yeah, they can trace that.
But you've never seen anything?
No, I haven't. And I know people use their cell phones in classrooms. I think, and I think that's relatively benign. I had a case a number of years ago, however, where the teacher member was, long story short, was conducting a lot of banking business from her phone. And it got to the hearing stage in front of the Professional Standards Commission, in front of an administrative law judge, and the Attorney General's office had subpoenaed the members' cell phone records and blew them up on big, you know, poster boards. And on one poster board was her cell phone records, and on the poster board right next to it was her classroom schedule. And so the lawyer walked through, you know, is this your phone? Yes. Is this, you know, did you call at this time? This is your record? Yes. Well, let's look at your classroom schedule. Were you supposed to be teaching while you were on your cell phone conducting personal business? And it was awful. You know, there was no place to hide, but they subpoenaed the records. in that particular case, but she had a lot of other issues going on. It was not an issue of her using her cell phone as much as she left the school property without permission. And then that she abandoned her classroom, which is a huge, huge mistake. And once she was caught abandoning her classroom, they just went all in on her. They just went all in and got her cell phone records. Sheila?
When you said she abandoned her classroom, like she didn't quit, she just would leave her classroom, or she just left at one time, or?
Yep. So the story is she received a phone call from a neighbor, and it was right down the street, as we're talking to cab schools. At least that's where I'm sitting. And rather than go to the front office, well, the neighbor said there's a break-in at her apartment. And rather than go to the front office and check out and tell them what's going on, she had an emergency. She had to get to her apartment. She went out the window of her classroom because her car was parked right outside her classroom window. So she goes out the window, leaves the paraprofessional in charge, and goes to her apartment, finds out, I guess, everything was okay. But when she comes back to the school, she doesn't go back in through the window, but she does go back through the front office asking for the principal. But guess where? The principal wasn't in his office. Guess where he was? He was in her classroom waiting for her to return. And so that triggered this major investigation, including, again, obtaining her cell phone records and comparing her cell phone records to her classroom schedule. So, yeah. So, getting into some of the law here. So can school employees be disciplined or discharged for their online social media activities? And I like to say maybe, but it's extremely difficult. Lawyers got to look at the facts, scrutinize them very carefully on a case-by-case basis. But the law is summarized on this slide. Your strongest protections of free speech, speech, and conduct are strongest only to the extent that you're speaking as a private citizen on a matter of public concern. So right away, when you're on the clock working at school, you're not going to be a private citizen in the vast majority of the cases. It's hard to think of a case where a public school employee is going to be seen as exercising a First Amendment right as a private citizen while they are working. Very, very difficult, if not next to impossible. And it must be, because speech must be on a matter of public concern as well. So those are two of the bedrock foundation principles that courts and lawyers look to. So for example, if I want to speak in front of the school board about, say, the acceptable use policy needs to be updated, we reviewed it, my association has reviewed it. I'm speaking as a citizen, taxpayer, voter, a grandparent or uncle. You want to be able to layer on your other legal statuses because you're there as an employee. I work for DeKalb Schools. I'm also here as a citizen, taxpayer, voter, and a member of NEA GAE, proud member of NEA GAE. And I'm here to talk about updating the acceptable use policy. That updating the acceptable use policy is a matter of public concern because all employees and all taxpayers of DeKalb County would have an interest in my speech. If I stood up and said, I'm Mike McGonigal, I'm a citizen, employee, taxpayer, but I'm here to complain about my TEKS evaluation. I'm here to complain that I didn't get planning time, and I'm upset with my principal not giving me planning time. There's a new law that says I'm mandated to have a planning time. My principal isn't letting me. Well, that would not be a matter of public concern. That would be Mike's, personal sort of private employment concern that would not be protected speech. They could just tell me, thank you very much, Mike, have a seat. And they wouldn't, and they could tell me to stop because the public speaking part of the board meetings are for public concerns, not for people venting their private grievances. Please use your local association and speak and act collectively. Who are we if we're not a union? Who are we if we don't act together as one? I mean, I think of our GT&EA founders in 1878 coming together out of slavery and forming a professional education association. Now that is working together on some very, very serious matters, and we need to bring that spirit back to GAE to begin to speak collectively, because public education is under attack right now, as you all know. Karen, do you have a question?
It always comes up, Mike, about like forwarding the GAE legislative hotline to the whole of the building, or if you have access to the whole of the school system. Would you want to comment on that?
Sure. In my view, that's not advocating a personal political view. We would say we are sharing information about vital matters that are happening at the General Assembly that affect all employees. It's not me expressing my own personal viewpoint. It's an organizational informational piece so that people know what's going on that affects their careers. And I don't know, y'all can tell me, have we ever been blocked from sending out our legislative alerts or updates on the basis that it's political and therefore prohibited? Anybody?
No, but our school has told us we're not allowed to send any kind of message out to everyone anymore.
Okay. Well, I tell you, what's good for the goose is good for the gander. So if they're prohibiting GAE from sending it out, they then have to treat everybody equally across the board and not allow other organizations that same access. Now that's the best I can say about that. And if they are allowing other organizations to have access, let us know, and we'll get it straightened out.
And would that not be something else, Mike, that a local, if there were enough buy-in, could take to the school board and say, we are only sending out information so you have an informed group of educators across the board?
Exactly. That's exactly right. And that's an appropriate frame. Those updates, they're not saying vote for a particular candidate or anything. It's just information from the Capitol so that you know what's going on that is impacting you in your career. So, okay. Well, it's my slide's not advancing. Huh. There. So there are limitations. Free speech is not absolute. There's some limitations. So it's not spoken if it's within your job duties, and that's as a result of the United States Supreme Court about 10 years ago came out with one of the worst, well, at the time it was one of the worst decisions, but as we know, they've recently come out with some really bad decisions on women's rights, on voting rights, affirmative action, a number of things. But this one dealt with a public employee's right to speak when this district attorney in California was exposing corruption in the police department, and he lost his job over it. Well, he sued the county. I can't remember if it was Los Angeles County or the city. And he said, I was exercising my First Amendment right of free speech by exposing police corruption. The case goes all the way up to the United States Supreme Court, and they said, well, now, not so fast here. You had a duty to expose corruption, and since it was part of your job duty to expose corruption, we're not going to recognize you as having a First Amendment right under the federal Constitution. So that, that reversed, decades and decades of free speech law as it relates to public employees. So what it means, though, is if you speak in your job duty, say, for example, you're advocating for special needs children not receiving free appropriate education, and you're retaliated against for that. There are other federal and state remedies in that context, such as the Americans with Disabilities Act. You're advocating on disabled children. Section 504 also has anti-retaliation protections. And the state whistleblower statute can come into play if you're retaliated against. And we have a solid record of suing school systems just on that basis. Special needs teachers advocating, retaliated against, lose their jobs. They don't have tenure, but we sued in federal court under the laws that I just mentioned. It wasn't free speech. We didn't have any free speech claims, but we won under disability law and our state whistleblower law. And as I said, the second bullet, if your speech deals with private or personal matters, it's not going to be protected. Or if your speech causes a disruption in the workplace, we'll see the Atwater versus Tucker case in 2018, what disruption in the workplace looks like. And if your speech is unlawful or untrue, that is not protected by free speech. You can say, Mike's a substandard lawyer. Okay, well, that's somebody's opinion. I cannot sue somebody for expressing an opinion. But if they said Mike has a criminal record for distributing illegal drugs at the elementary school playground, I can prove that's false. And so that would be something where I would have a valid claim for defamation. Let's see. So this is what's disruption, and this is a a good example, a terrible example of what disruption in the workplace is. So it basically boils down to the teacher, Miss Tucker was a middle school teacher down in Tifton. And during a holiday parade in 2016-17 in downtown Tifton, there were some Black Lives Matter marchers holding signs, Black Lives Matter. Okay. So she gets on her Facebook, and what she posts on Facebook is the following. It's turned into a race matter. What about the thugs that beat the father with his vehicle because he didn't slow down? What about the thugs that shot the college baseball player because they were bored? If the dude hadn't stolen, he would be alive. I think the sign should read, take your hood off, pull up your dang pants, and quit impregnating everybody. I'm tired of paying for these sorry thugs. And she goes on. So using the court's analysis, she's speaking as a private citizen on a weekend, her private time. She's speaking on a matter of public concern. She has a right to talk about Black Lives Matter. The problem with her case is she's a public school teacher. And can you imagine being a Black or brown child in Miss Tucker's classroom, or the parents of the Tift County Middle School? Can you imagine the disruption it caused in the community? Quite substantial disruption. And so it did result in a 5-day suspension, and Miss Tucker had to take some diversity training. But that's an example of disruption. And there was a lot of, telephone records and email records to show what the disruption was. It was not a hypothetical disruption. It really hurt. It really hurt students and parents. So we'll go through some of these. They're pretty basic, but it's still good to refresh. So on the first day of school, you ask for your student's personal email address to contact them if they're having problems in class. Not a good idea, because you're already blurring the professional boundaries under standard 2, and those lines need to be very clear. So I would not say that asking for the student's personal email address is a good idea. So 2, you heard a funny joke on the radio on the way to school, and you use the school computer to email your friend from your school email account. Again, based on everything we've said, that's probably not a good idea, because you might know me really well, and I might think that joke is funny, or it could strike me as very unfunny and offensive. And also, I might forward that email to other people, and they might forward it to even more people. So it can go on and on and on. And the next thing you know, after you've hit send, you've created some controversy. You give your students' parents your cell phone number for emergency purposes. This I find is very common, especially with band directors and coaches, okay? But once you give your cell phone out to the parents, even for legitimate education purposes, just know you've lost control of your personal data. And that's what happens in this scenario. The student texts you if you're going to her soccer game that evening. And rather than not responding, you respond, yep. Now, normally the texting exchanges do not end with that. There's usually a whole lot more that goes on after that. But even if you respond, yep, and it's innocent, even if it's innocent, the student can and is likely and has been known to take it all out of context and tell all their friends that Mr. Mike, he likes me. He's wants to date me or whatever. Look. So just know that even innocent conversation with a student after hours about a non-school related activity can end up in a very messy employment situation and certification fight. And I guess someone had mentioned in one of these sessions in the past, if you don't want to use your own personal phone, you can get Google Voice. It's free. Some of our members buy cheap burner phones out of their own pocket for school use, but that way, they're not going to be using their personal device and having that subpoenaed. You don't want that subpoenaed, trust me. So you maintain an X or Twitter account where you discuss discipline proceedings brought against you by the district. Well, that wouldn't be protected free speech, would it? Because why? That's personnel, that's personal. That's not a matter that all tax-paying citizens would really want to know about. And I could be accused of trying to influence witnesses in the proceeding as well. I'm kind of reminded of what's happening in Fulton County, influencing witnesses. We shall see whether Mr. Trump is going to abide by the conditions of his bond. 5, you maintain a Facebook page where you discuss your views on the upcoming elections. Yes, that is First Amendment protected speech. You have a right to express your political viewpoint on your private time, on your Facebook page. It's no different than, putting in a yard sign in your front yard, or, I have political posters, in my office, and sometimes I stick them in my car or put them in my house. And so that's protected speech. And there's a lot of good law on that. 6, you maintain a personal blog, and one of your co-workers posts a disparaging comment about one of your students. Well, I did this presentation a number of years ago, and a hand went up in the audience, and I'm trying to remember that it was a perfect answer. She said, "Oh, I've had that happen." I immediately, take that person off my blog or Facebook, or I unfriend them. I'm not gonna, if they're a friend, I'm not gonna risk my career over, somebody's boneheaded post on my Facebook account. So she took it off, unfriended them. And then immediately when she got to school, she told the school principal what happened. And I learned along the way that going to administration in these situations is really smart to try to defuse a situation, because the way technology is today, the principal probably already knows and may be coming looking for you if you don't reach him or her first. So it's good to try to beat them to the punch and tell them what happened, what was posted on your Facebook the night before. So you post a weekend rally protesting police brutality, say it's on your Facebook page. So I'm at a protest downtown Atlanta, protesting police brutality, voter suppression, inhumane immigration laws, that sort of thing. That's completely protected speech, completely 100%. And the story behind there, somewhat related, is we had a GA member protest the Trump administration's immigration policies, and he was arrested and hauled away illegally. It was dismissed in the criminal court, but his principal put it on his TEKS evaluation, saying that it did not reflect well on this is Gwinnett County, and the Gwinnett County school community. And we wrote the principal and their lawyers a letter saying, look, he was engaging in First Amendment protected free speech and conduct, and you cannot use that against him in his employment as a public school teacher in Gwinnett County. Well, they ignored it, and you know GAE and its legal department. If you're going to ignore us, it won't take us too long to file a lawsuit, which is what we did. And so we finally got their attention, and the case settled rather rapidly, like within a month. And everything worked out well. His evaluation was purged, it was cleansed for the right reasons. He got some money and we got some attorney's fees back. But you can protest that without fear of retaliation. Yep. Number two, you post a local newspaper article favorable to a political candidate. That's absolutely, this looks like number one. That's free speech, protected. You write a letter to a publication that's critical of the school board and of its actions or ideas. The only thing, as you know, by what we've discussed so far, you can be critical of the school board as long as it's on a matter of public concern. Public concern. I don't know about, people are going to be writing letters up to Cobb County, I imagine, in the Marietta Daily Journal, criticizing the board over its firing of our GA member, Katie Rinderly. That's a matter of public concern. Members of local association have every right to express their criticism of that decision. That's a matter of public concern. It's in the public domain. But you just can't get into personnel matters. Like, again, I write a letter to the editor and I'm upset with my principal because he's not giving me planning time or something like that. Or you post a joke on Facebook that your student should be locked up. Well, that might be a good idea, but seriously, that's not First Amendment protection. You could face some discipline over something like that. You're instructed not to discuss with students your personal opinion on political matters. Okay, you're given a directive. Don't discuss your personal views on political matters. In a classroom discussion on racial issues in America, you tell your students on Instagram that you've recently participated in a Black Lives Matter demonstration. That's going to be a close one, in the sense that if you've been instructed and directed not to do that, you could be found liable for insubordination, aside from the fact that the speech in other contexts could be protected. Had you not been instructed not to do that, I'd argue you have a better chance of it being brought to your attention. Don't do it again. But because you're expressing your personal political viewpoint as a classroom educator to your students on Instagram, we don't have that right as public school educators to express our personal political viewpoints in the classroom. Our speech has to be aligned with the curriculum. So, although this is not on social media, I just wanted to, show people or remind people, if you didn't know, what sort of resources we have. In 2015, GA sued the Walker County Board of Education because one of our members wanted to speak to the Board of Education publicly about their grading policy. And he eventually was never given the opportunity to address the board on a matter of public concern. He was completely blocked because, as you see in the court in 2017, it gave the superintendent unfettered discretion to silence speech that he disagreed with. And the court issued a permanent injunction on the face of the policy as it's written. That's very rare. There are not many cases that have been decided like that in the country. So this had a huge positive impact to create or expand educator free speech rights across the country. It's being cited across the country. Now, the last but not least, look at the legal fees that we got back from the taxpayers of Walker County. Hated to do that, Walker County taxpayers, but nobody has $330,000 to fight the good fight, right? That's why legal services exist. That's why we're a better program than other organizations. If our members' rights are being violated as they were here in Walker County, or as they are under the Divisive Concepts Law, we have the resources to take the fight straight to them and win. Doesn't cost the member any more out-of-pocket fees or costs or any other dues. So with that, I'll take any questions or comments, good or bad. You can always email me with your comments, or if you have questions that you want to discuss offline, it's mike.mcgonigal@ga.org. You can find me on the website. My number is 678-837-1126. So, thank you.
Well, thank you, Mike, for giving our members all of that important information. Here at GAE, we pride ourselves on keeping our members informed. And once again, you can put any questions that you have in an email to Mike McGonigal. It's mike.mcgonigal@gae.org. If you would like to email me as well, I will see that Mike gets those questions. That's sharon.doe@gae.org. Thank you all for joining us today, and I hope you have a wonderful rest of your week. Good night.
There was a Ms. Holiday. This is recorded and it'll be on the GA website in the next day or two, so that you can watch it again, take notes.